CSNPEI channel, and I will be sending out a link to everyone at the end as well. So as I was saying, my name is Ezra Santana. I'm the membership coordinator for CSNPEI. Welcome to our last Lunch and Learn of this year. I'd like to start by acknowledging that Epiqua, Prince Edward Island, is located in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq people. The Epiquinoa Mi'kmaq have occupied this island for over 12,000 years. CSNPEI is committed to listening to and uplifting Indigenous voices in the ongoing conversations surrounding Indigenous peoples' rights, cultures, and history. We believe in land back and are committed to partaking in decolonization efforts, both within ourselves and in our communities. CSNPEI's Legal Lunch and Learn returns this year to create a space where nonprofit staff and volunteers can come together and learn about legal matters relevant to the community sector. This series is made possible through the generous support of the Law Foundation of Prince Edward Island. As I mentioned, for the folks who are just coming in, if you could put your name and the organization you're with, if any, in the chat, that would be very helpful for my attendance keeping records. We do have a feedback survey that we prepared for this event, and it would also be really helpful if everyone could fill it out whenever you feel like you have time. It's pretty quick. So I'll be sending a link to everyone in the chat later on. And I am recording this session for folks who might miss it, or if anyone wants to check it out afterwards. It will be available on our YouTube channel, and I will be sending a link to everyone who signed up for it as well. So now I will welcome and introduce everyone to our speaker, Olivia. Olivia is a lawyer at McInnes Cooper whose practice focuses on privacy law and litigation. She supports clients across a wide range of privacy and technology matters, including advising tech companies on the legal obligations and potential liabilities associated with launching novel AI technologies in Canada, guiding public bodies on freedom of information requirements, and conducting contract reviews. Olivia also drafts privacy policies, develops training materials on privacy best practices, and provides privacy breach management support. In addition, Olivia has extensive experience in health privacy matters, including advising on custodianship and management of health records, and assessing privacy considerations related to the use of various technologies and AI in healthcare settings. Off the clock, Olivia enjoys volunteering in her community, traveling, playing piano, keeping active, and spending time with family, friends, and her two dogs. So, welcome everyone. Thanks for joining, and welcome, Olivia. I don't know. I'm pretty sure you can share the screen if you want. You should have permission.
Yeah, okay. I'm just gonna try and set that up here right now. Let me see here. Sorry, this might just take 1 second.
No worries. Thank you everyone for putting your name and your organizations in the chat. That's very helpful.
Okay. Oops. I think this might just take 1 second here. My apologies. Okay. Is that clear? Are you able to see,
Yep,
are folks able to see the slide and are you seeing privacy, data protection, and cybersecurity?
yep, it should be good.
Okay, fantastic. Um, So I will take it away then, and certainly just give me a shout if, for whatever reason, my screen sharing isn't working or you can't hear me for whatever reason. I know that sometimes, even though we've been at these virtual meetings for a number of years now, sometimes we still run into issues. So please do just give me a holler if there's a problem. But with that, I'll just introduce myself and thank you for the lovely introduction, Ezra. Like Ezra said, I'm Olivia. I'm a privacy and litigation lawyer at McInnes Cooper. I practice in Halifax, but work with clients all over the country, but mostly in the Atlantic provinces. And I'm very thrilled to be here today. So thank you for having me. So I just wanted to give you a little agenda of where we're headed with our discussion. Um, I'll be beginning with a quick overview of why privacy is important or why it matters. And then I'll move into the privacy law landscape here in Canada. Then I'll discuss some privacy management program elements and considerations, as well as privacy impact assessments. From there, I'll be speaking about breach response and obligations and CASL, Canada's anti-spam law. And then finally, we'll wrap up with managing service providers and managing or addressing business transactions and personal information. So that's where our discussion is headed today. So, question number one is that maybe you folks are wondering, and I find oftentimes when I deal with individuals who aren't maybe working in the privacy spaces, why does privacy really matter? It seems that in 2025 you're always going to be dealing with a breach, and that may be the case, but unfortunately, the bottom line is that um, the risk is high. When we're dealing with privacy, we're often dealing with sensitive information, and people don't like to be caught off guard in the manner in which their personal or sensitive information is shared or disclosed with others. And oftentimes people characterize it as kind of control over your own information and autonomy. So privacy does mean different things to different people, but oftentimes when it's discussed, it comes down to risk and it comes down to control and autonomy. So um, beyond that, I understand that everyone here today, or most of the folks who are here today, are from nonprofit organizations, and with any organization, client and customer trust and confidence and expectations are completely and absolutely vital. They serve as the foundation of any business or other relationships. So privacy certainly has a role to play there. We also have to comply with legal obligations. And like I said again earlier, the stakes are high when we're dealing with privacy. A privacy issue or breach can lead to bad press and damage to your reputation. It can be expensive to fix, although I'll get into a minute. You folks likely aren't subject to that legislation, but I'll chat about that in just a second here. And the potential for lawsuits. So the stakes are indeed high. Now, just to zoom out a little bit here, I'm going to tell you kind of just at a high level what types of privacy laws we have in play in Canada in 2025. Because privacy is quite complex in that it's a mosaic. There are all of these different privacy laws, and they apply to different things in different circumstances, and they work together to create this mosaic. But it's not really straightforward. It's not as though we just have one law that says this is the law that governs privacy, and that's all you need to know. It would certainly be much simpler, probably in many ways, if that were the case, but it's not. So. What we have is a couple of key categories, and of course there are others, but what I just want to highlight today was we have PIPEDA, which is Canada's private sector law, and it's kind of what we refer to as the gold standard in terms of how we conduct ourselves from a privacy management perspective. So PIPEDA only applies in the private sector, and I know or I understand that most of the folks who are here today are nonprofits. Now, it's quite a detailed legal analysis to determine whether or not a nonprofit is subject to PIPEDA. The bottom line is that often they're not. So what I'll say is, even if you're not subject to PIPEDA, it's really best practice to try and follow PIPEDA anyway, because, like I said, it is the gold standard, and we want to be handling people's personal and sensitive information as best we can and as safely and ethically as we can. So, just with respect to PIPEDA, I'll reiterate. It probably doesn't apply to your organizations. It might, but it probably doesn't. But in any event, we typically tell all of our nonprofit clients that it's best practice to follow its guidance anyway. Then we have a whole other category of privacy laws for health privacy, and another category for the public sector. So that would be, your school boards and your hospitals. And I'm sure many of you are familiar with, for example, freedom of information legislation. So under freedom of information legislation, individuals can request access to certain information. Well, in theory, most information from a public body to promote transparency. So you may see, for example, sometimes in the news that a journalist has made an access to information request for access to information to wait times at the hospital or something like that. So those are three kind of key categories of privacy laws. In Canada, we've got the private sector privacy law, which is PIPEDA, health privacy laws, and public sector privacy laws. Nonprofits often don't fall into any of these categories depending on the type of work that they're doing. So once again, if there's one thing that you take away from today, it's that I want you to try to follow the gold standard that's set out in PIPEDA. So, what I'm going to be doing for a good chunk of this presentation is just reviewing kind of those principles that are set out in PIPEDA that should guide your privacy practices, or that we typically recommend our clients apply to guide their privacy practices. So the way that PIPEDA and most privacy laws are set up is that it applies to, in this case, the collection, use, and disclosure of personal information in the context of commercial activities. So it applies in a few other contexts as well, but we don't need to get into that for the purposes of today's presentation. But like I said, what is the relation here to nonprofits? You're probably sitting here thinking, well, I'm not engaged in commercial activity, I'm a nonprofit. It comes down to best practice, like I said. So to provide you with, I guess, just a short overview of where all of this is headed, Canadian privacy law is based on a few key themes, I guess is what it comes down to. So we've got one of them being reasonable purposes. So we want to make sure that we're only collecting people's sensitive information, for example, for a reasonable purpose. Like, we shouldn't be collecting it if we don't need to. Then we've also, another kind of theme, I guess, that we see arising is that we need clear notice to the individual of the purposes for which we're going to be collecting or using their information or disclosing their information to someone else, or another entity or organization. So the idea here is this kind of comes down to autonomy and, I guess, really kind of like informed consent. We want people to know why their information is being collected, why it's being disclosed. So that's kind of a second key theme. And then a third key theme is just about, like I said, obtaining consent to collect or use or disclose the information for those reasonable purposes. So this is kind of the big picture. This is the moral of the story. This is what we're trying to achieve at a high level. Now, under PIPEDA, it integrates what's referred to as the 10 fair information principles upon which Canadian privacy laws are based. And that's called it's the CSA model code. But really all you need to know, or what I would suggest you know, is that there are kind of these just 10, I guess, rules or guidelines, or however you want to think of it, to guide your privacy practices. And I'm going to take a minute here in just a second to go through each of those 10, and I think you'll see how it comes together. So, like I said, I just want to take a quick moment here to define some of the key terms that we're going to be talking about today, because they do have a distinct legal meaning. So I've spent some time at this point talking about how most privacy laws, including PIPEDA, are gold standard. pertain to the collection, use, and disclosure in the course of commercial activity. And I think you can probably at a high level it can get a little bit technical, but hopefully folks understand what collecting information may be. That may be asking your client or a participant in your program for their email address and their mailing address so that you can mail them your newsletter about your organization. So that would be a collection of their information. And then use and disclosure. Use has a little bit, it can be a bit complex how we define use, but I think for today's purposes, you can just consider it as its plain and ordinary meaning of that word. And then disclosure is disclosing the information to someone else. So for example, sometimes the law will require that you as an organization have to disclose someone's information to another organization by law. Or perhaps you have an agreement with another organization or with whoever it may be to allow you to disclose or share that information. So those are kind of those key terms. These are the activities that we're talking about. We're collecting, using, and disclosing this information. Now, it's all about personal information because the idea is that your privacy is kind of tied to you as a person. So if there's some information that's out in the world that it can't be tied to you, that's typically not subject to privacy laws because there's no real reasonable expectation of privacy if the information isn't associated with someone. And now personal information is defined as information about an identifiable individual. So that may be your name, it may be your address, your income, or a client or a participant's birthday, their SIN number, basically any information that can be traced back to an individual. It doesn't include business contact information. That is just one thing to note. And like I said, we're only collecting personal information for reasonable purposes. And that's kind of just a baseline reasonableness requirement. Now, like I said, I got a little bit ahead of myself here, but I do have some definitions here just of those terms in case it's helpful for you kind of understanding what each of them mean. But collection or collect under the legislation is kind of defined or described as gathering, acquiring, receiving, or obtaining personal information by any means from any source. So it may be that you collect it indirectly about a person, like you collect it from someone else about a certain person, or you may collect it directly from the person themselves. Use is defined as handling or dealing with the personal information, but it doesn't include disclosing the information. So perhaps you're using that information, perhaps you're using a participant's banking information in order to bill them. That might be an example of a use. And then finally, we've got disclose. And disclosing information is all about making that information available or to release it to another organization or another person, but it doesn't include use. So what you can see here is that use and disclosure can maybe sometimes be easily conflated, but they're not the same thing. So, like I said, we're going to spend a lot of time today just going through the 10 principles that are meant to guide your privacy practices. And you want to make sure that everything that you do in relation to privacy is in alignment with these principles as a nonprofit organization. So, these principles form kind of the ground rules for collecting, using, and disclosing personal information, and for providing access to that information. And the rules or these principles seek to give individuals control over how their personal information is collected and used and disclosed. So those principles are listed here on the screen, and I'll take some time going through each of them. But we've got accountability, identifying purposes, consent, limiting collection, limiting use, disclosure, and retention, accuracy, safeguards, openness, individual access, and challenging compliance. So these are our guidelines. This is the North Star that we're following when we're dealing with privacy law. Now, sorry, just one second. I think I skipped a slide. Right. So the first principle is accountability. And as I'm sure you can imagine, an organization like the ones that you folks would work with is responsible for the personal information that's under its control. So if it's not under its control, you're not really concerned with that. But if it's in your control, that is your responsibility. And the organization needs to designate an individual or individuals who are accountable for the organization's compliance with the principles that are set out in that model code. So those 10 principles that I just mentioned. So in practice, what this looks like is we recommend that you appoint a privacy officer, which is just someone who is going to be the person in charge of all things privacy. They may be a point of contact for your folks on the ground, but appoint a privacy officer. In addition, the organization should remain accountable if information has been transferred to another organization for processing. So, for example, perhaps you, like I said earlier, you take someone's billing information and then you send that over to Stripe or PayPal or whoever it may be that's dealing with that information. You still are accountable and responsible for it. So that is another piece. And then a third piece of accountability in terms of accountability is that you want to implement practices and procedures to implement the standards, which I realize is kind of one of those strange wrap your head around situations, but it's all about making sure that we're actually implementing these standards. So that's the first principle, accountability, making sure you're accountable for your privacy practices. The next of the 10 principles is referred to as identifying purposes. And here we're talking about the purposes for which the information that you're collecting is being collected at or before the time that's happening. So on the ground, what does that look like? It means you're actually writing down why you are collecting personal information. And that may be in a privacy policy or something like that. But you're documenting that. You're also identifying orally or in writing the purposes to the individual at the time the personal information is being collected. So when you're collecting someone's personal information, the gold standard is that you're letting them know why you're collecting it. And sometimes it might be obvious, but sometimes not so much. The third principle is consent, which I think probably doesn't come at us as a surprise to anyone, but generally we want people to have knowledge and be consenting to the collection, use, or disclosure of their personal information. So we don't want to be collecting someone's information without them knowing it or without them wanting us to. That certainly is not honoring people's autonomy. We want them to be consenting to our handling of their information. So to make sure that consent is informed, we need to make, as an organization, a reasonable effort to advise the individual in an intelligible way. So not in a way that they have no idea what you're talking about, but in a way that's kind of comprehensive and digestible of the purposes that we're collecting their information for. The form of consent will vary depending on the sensitivity of the information. So, for example, if you're collecting someone's SIN number, the consent should probably be quite express. But if you're collecting, what would be a low risk piece of personal information? I guess perhaps just it could be the city that you live in or something like that, like something quite broad like that. And that wouldn't require necessarily a stringent consent. You cannot require consent for the collection, use, or disclosure of personal information beyond that's required to fulfill the explicitly stated and legitimate purposes. So that's to say, if you only have consent for consent to collect someone's information for the purpose of facilitating their participation in one of your programs, you can't be collecting their consent for their participation in your programs and your billing and this and that. So they need to be aligned. And then also another key piece of consent is that consent is dynamic and it can be withdrawn. So it's not as though you consent once and you've made your decision, you're out, no changing your mind. No, consent is dynamic and it can be withdrawn. However, I will note, as I said earlier, sometimes there are exceptions to consent. In my practice, I see that, I would say, largely in terms of like in the health world, if there's someone, for example, who may be at risk of harming themselves or another, then sometimes you may be disclosing their information without consent. The next principle is referred to as limiting collection. And what we're talking about here is that we shouldn't be collecting more information than we actually need, because that is just an invasion of someone's privacy. If you don't need it, why are you collecting it? Um, so I guess in a more formal sense, this would be described as, collecting information in a manner that's limited by that which is necessary for the purposes that the organization has defined or identified. And it should only obviously be collected for fair and lawful means. So we're not collecting information that we don't need. We're not collecting information that is, if it would be unfair to do so. And we're not collecting information in any unlawful manner. And in practice, what that looks like is identifying the purposes, like we said before, and then limiting the collection to that which is necessary for those purposes. So it all kind of comes back to the purposes. And then also, we like to remind our clients and folks to be honest. Don't collect information by any misleading means. We want everyone to be in the loop. We want people to know what they're consenting to. No, try to avoid the small print. Now, the next principle is limiting use, disclosure, and retention. So we've talked about limiting collection, but we're also limiting use, disclosure, and retention. So what that means is it's very similar to before. We're not using information for a reason that we don't need to. We're not disclosing it for any reasons that we don't need to. And we're not holding on to it for any reasons if we don't need to. So it's all kind of about what do you actually need here and keep everything, all of your actions aligned with that. So, for example, you're only holding on to the personal information that you collect for as long as it's actually necessary to fulfill the purposes that you collected it for. So if it's like you collected this information for someone to participate in one of your programs and that program runs for 4 months, you probably don't need to keep that information for 15 years in your records because the program's long done, and there probably wouldn't be anything arising from that program that you would need that information for. Now, once again, we've got some examples of what that looks like on the ground to actually enact this principle. And that may be, for example, limiting use, disclosure, and retention of information to the purposes for which it was collected unless you get further consent or and you document that new purpose. It may also just be making sure that you destroy or make information anonymous if you don't need it anymore. Moving right along, the next principle is accuracy. So the idea here is that any information, personal information, so that is once again information about an identifiable individual. So it's not, anonymous data, but information about someone. We want to make sure what we're keeping, what we're holding on to, is as accurate, complete, and up to date as is necessary for the purposes for which it's going to be used. And I think this is hopefully quite self-explanatory, but this only really becomes an issue when personal information is used to make a decision about someone. So, for example, there are a number of ways in which perhaps you're processing an application or something like that. You want to make sure you have up-to-date and complete information about the person that you're considering hiring or putting into a role or accepting into a program. Otherwise, it would be unfair if you're not basing it on current and accurate and complete and up-to-date information. Next up, we have safeguards. And the idea here is that all personal information should be protected by security safeguards that are appropriate to the sensitivity of the information. So again, this is kind of similar to what we were talking about earlier. If you've collected someone's SIN number, you need to protect that very, very strictly and carefully. That's very sensitive information, or perhaps another type of information that would fall into that very, very sensitive category would be a lot of health information, banking information as well. And you need to protect that information from threats. So the security safeguards need to protect against theft or loss of the information, as well as unauthorized access, which is kind of what we're seeing more and more in 2025. It's not so much someone is coming in and stealing your documents from your filing cabinet. It's more so the hackers that are causing the problems. But kind of all of this, we're protecting against people copying or modifying the information inappropriately. And beyond that, you also want your organization to make sure you're using secure disposal methods. So if you've got really sensitive information, you're putting it in like a secure shredder or something like that. You're not just kind of leaving it out or putting it in the normal garbage. You want to make sure that all of your service providers take care of your data. So that's, for example, you've got like I've mentioned Stripe a few times. If Stripe is kind of your payment processor, you need to make sure that they are taking care of your data while they have it. Or perhaps you use like a customer service line that is based elsewhere, and they're conducting this work on your behalf. They're allowing your participants or clients to contact them to provide a service. They need to take care of your data, and I'll get into that in a bit. In addition, you need to apply real diligence in choosing a service provider and what technologies to use. And then we've also got breach obligations, and I'm going to get into all of that later in the presentation. The next principle is openness. So the idea here is that your organization should be making readily available to individuals specific information about your policies and practices relating to how you manage personal information. So again, this is kind of just about transparency and accountability. You want people to know how you're handling their information, because that's just going to make sure that everyone's on the same page and help set expectations. But what that means is that organizations should have a privacy policy that really helps set expectations for folks. And the information that's made available should include a number of things, like the contact information for a privacy officer. So like I said, that person who's designated to deal with all things privacy for your organization. And another example would be a description of the type of personal information that the organization holds, and including a general account or kind of summary of how it's used. So that's all about transparency. We're on to our second last of the principles now, and that is individual access. So here, what PIPETA says, which as we know is our gold standard, so it's what we're striving for. Upon request, an individual should be able to become informed about the existence, use, and disclosure of their personal information and be given access to that information. And an individual should be able to challenge the accuracy and completeness of the information and have it amended as appropriate. So I think what's oftentimes helpful or easy for people to conceptualize is your health record or your chart. And I know that probably not all or maybe not even most of you would be dealing with health information, but I think that's just one that's a good example in terms of helping you wrap your head around. You have a right to access your chart. I think most folks know this. And you also have a right to correct anything that's inaccurate in there or incomplete. So it's similar for your organizations. And a lot of this comes down to how we're using information to make decisions, because like I said earlier, we want to make sure the information is up to date if we're using it to make decisions. But the idea here is that under PIPETA, at least, and what we would strive for as a nonprofit not subject to PIPETA, is that if you do get a request from someone to access their information that you're holding about them, you should get back to them within 30 days, preferably much sooner. You need to let the person know. You need to let them know that it's been disclosed, and you need to keep a record about how your data is used. Um, Sometimes there will be a small charge. I know that you folks aren't subject to PIPEDA, so you probably wouldn't be providing or making a charge, but that'll be up to you. And it needs to be comprehensible to the individual. So if you're giving someone their information, but they have no idea what they're looking at, that's not helpful. So that is the individual access principle. And then our last principle is challenging compliance. And this principle pertains to individuals being able to address challenges concerning compliance with the other principles that we talked about. So really it's about holding organizations accountable and making sure there's a mechanism for individuals to be able to do that. And what this looks like is your organization should have something in place, some sort of method for receiving complaints and addressing them properly. And then you should also let the individual know that they have a right to complain to the appropriate authority. Now, for you folks, there might not be an appropriate authority depending on what it is that you're doing, but you should still have some sort of a feedback process regardless. So those are the 10 principles, and I hope that it makes sense that what I'm trying to say here is we've kind of got these, I guess, guiding rules, if you want to call it, almost like 10 commandments, but not obviously, but you can think about it maybe that way. But the idea is that this is how you want to be guiding your privacy practices within your organization. Now, privacy, just moving right along into something related, is privacy management programs. And the point of a privacy management program is to maintain compliance with privacy laws, to mitigate data-related risks, and to foster a culture of privacy across the organization that you're working in. So you can kind of just think about it as like a plan for privacy. It's your privacy plan, but typically we refer to it as a privacy management program. And there are different things that you would want to include in your privacy management program or your privacy plan, but I'll get into those in just a second here. So I'm not sure if very many of you would have a privacy management program or a privacy program in place, but it is helpful to have this just so that there's a guide for your organization and I think it's also just helpful because it encourages organizations to actively turn their minds to privacy and consider, how are we actually handling privacy? Like, are we up to date? Do we have gaps? So it's just kind of a good 360 type analysis to do. But what I guess the categories would look like typically would be you would start with data mapping and taking an inventory of the personal information that you hold. So the idea here is just like, what personal information do we even have, and what's it being used for? Where is it going? Like, who are we sharing it with? It's just kind of making a big map of the personal information that you have as an organization and mapping out where it's going, how it's being used. So that's kind of one element of a privacy management program. Another element would be policies and internal controls. So that is, I think, probably quite straightforward, but that would just be policies about how you collect, you use, you're disclosing the information. So in effect, a privacy policy. Now, we also want to be supporting business operations and making sure that that is covered. And we're also looking at ongoing compliance and training. So here, the idea is we want to make sure that people are keeping privacy best practices in mind. And that will probably be more specific depending on what it is your organization is doing, but that's kind of at a high level. And then we've also got supporting innovation and breach and incident management response. Now, I'm going to get into breach and incident management response in just one second here, because that is kind of one of the biggies. But just very quickly, before we do that, one thing that is often helpful to do when you're implementing a privacy management program is if you're using a new technology or there's a technology that you've been using for a while and there's been a change or whatever it may be, or just a new type of collection of personal information, what you can do is what we call a privacy impact assessment. And effectively, what that comes down to is it's kind of like a lovely guide of questions to ask yourself when you are handling people's personal information to just consider the risks. It kind of walks you through a framework of different considerations that should flag risks for you that you may not otherwise have identified. But um, here, what I have is just a kind of, I guess, a framework for uh, conducting a PIA. First, you would consider whether or not you need to do a privacy impact assessment. Then you define the scope. You would map the data flow, so how you're collecting it, and then where's it going from there, and who's it being shared with. Um, all of this is just to say that these privacy impact assessments can be really helpful for flagging, like helping you to flag issues. And some of the provincial governments have particularly helpful templates that you can use that will kind of guide you through the process. So, for example, I've got a picture of a template from Alberta up here, and I believe the Privacy Commissioner of British Columbia also has quite a helpful template. But it just kind of walks you through a series of questions of things to consider, and it may turn your brain to something that you wouldn't have otherwise thought of. Now, transitioning into breach response, what we often tell our clients is that unfortunately in 2025, it's not a matter of if you suffer a privacy breach, it's more when, because it is just so rampant right now. And I'm not sure that that's going away, unfortunately. But what I've got here is a number of news headlines just to show, and what you can see here is that it's all about, data breaches. It's just to show that, these things make the news, unfortunately. It's a big deal. The risks are high, the sensitivity is high. And you do want to be treating these matters with caution. So what I have here is kind of a breach response pathway, if that's helpful for you folks to kind of conceptualize what you might do in the event that you suffer a data breach, which hopefully you don't, but you might. So the first step that we're going to, or that we recommend you do or implement, is to contain and assemble. So what this comes down to is kind of taking immediate common sense steps to limit the breach. So we're immediately containing it. We're shutting down the system that was breached. That might be one really obvious thing to do, or you're revoking or changing the computer access codes, or perhaps correcting weaknesses in the physical or electronic security that's at play. So what we're doing, we're shutting it down. We're containing the problem and we're assembling our ducks. So in addition, at this stage, you want to designate an appropriate individual to lead the investigation just to make sure everything's coordinated. And this person obviously should have some sort of experience, at least in dealing with matters as these. You also need to determine the need to assemble a team, which could include representatives from appropriate parts of the business. So you may have a bunch of different folks involved in managing the breach, or in your case, in an organization. And you also want to determine who knows about the incident. Like, we want to just get a pulse on that. Who knows? Who knows externally? Are we at the preliminary stage? Hopefully we're still there. Hopefully we discover the breach like well down the road. But you need to escalate things internally as appropriate. And including informing the person within your organization that's responsible for privacy compliance. And then also at this stage, we're not compromising on the ability to investigate the breach. So be careful not to destroy any evidence that may be valuable in determining, the cause of the problem or allowing you to take appropriate corrective action. So that's just something to be mindful of. Next up, or I guess part of that is we're evaluating. So start with a root cause analysis with a view to developing communications. So what I have here is just a little bit of a flow from day zero to, third party responsibility or failure of oversight of the service provider in terms of figuring out who's responsible for this. You want to evaluate whether the legal threshold for reporting or notification is required. You folks probably won't have specific reporting obligations, but I'll get into that in a minute. And if you do need to report to a privacy commissioner, you want to start drafting reports as soon as you're able. Now, sorry. What we'll do here next is it's a good idea to engage outside counsel to assist you with the breach response process. This is especially the case where it's determined that it's important to maintain privilege. So privilege is kind of like I guess it's like an umbrella that goes over certain information that is subject to a particular relationship. So, for example, like a lawyer and client relationship is subject to a bit of, I guess you can think of it as a cone of silence. Like if you tell your lawyer something, they're not supposed to tell anyone else because it's privileged. So you want to be maintaining privilege regarding certain communications. So it's a good idea to retain outside legal counsel because that will be in all odds subject to solicitor and client privilege, that information, so that it can't be used against you later. And you also, an external lawyer can help you assist, or can assist you in determining your legal obligations and how you might respond, of course. Now, the third step is notification. And like I said, you folks probably aren't actually required to notify anyone at law, but oftentimes it's best practice to do so depending on the circumstances. So what I'll say about that is typically the threshold that we apply and that the law applies, which doesn't necessarily apply to you, but is good guidance, is whether or not there's a real risk of significant harm associated with the disclosure. So, obviously we don't want any information being breached. But like, does the breach rise to the level that someone's data has been released and there's a real risk of significant harm? So, for example, if really sensitive data was released from one person in the organization to someone else in the organization, like that's not really a risk of significant harm. You know exactly where it went. It was within the organization. Like that wouldn't be a breach even. But if, it went out to you determine there was a hacker and you have no idea who the hacker is, you don't really know what they accessed, but they accessed some information and it was all very sensitive, that would probably give rise to a real risk of significant harm. So typically this real risk of significant harm phrase, I guess, or test is our threshold. So like I kind of alluded to, real risk depends on the sensitivity of the personal information that's involved in the breach, and the probability that the personal information has been or is being or will be misused, as well as potentially other prescribed factors. And significant harm includes a number of things. It can be anything from bodily harm to humiliation, damage to your reputation or your relationships, loss of business opportunities, identity theft. It can be a lot of things. So it's a contextual analysis is what I'll say. But this is typically the threshold that we'll say, well, do we want to report? Do we need to report? Should we report? We say, all right, let's think. Is there a real risk of significant harm? So that's kind of what's going to guide your decision as to whether or not to notify. So if you are going to be notifying individuals about a breach, you want to provide them with a description of the breach. You want to tell them when the breach happened. You want to describe the personal information that was involved in the breach so that they have all the relevant information. describe what you've done to contain the breach, and also provide contact information so that they can stay tuned. Now, a key thing that we tell our clients is you want to sweat the small stuff when it comes to notifying the individuals. Making an apology sometimes, depending on the circumstances, will make a world of a difference. Sometimes, just providing them with an opportunity for credit monitor. Excuse me. For credit monitoring, like if you offer to pay for that for them through Equifax or something like that, people will be quite grateful because, so your organization was hacked and there's nothing you can do about it, but you know that someone accessed your program participants or your client's business information, their banking information. And there's nothing you can do about it, but offering to pay for credit monitoring makes a big difference. So all of these things, we want to be sweating the small stuff here because that goes a long way. Now, our final step in the breach response plan, I guess, is to respond and regroup. So at this stage, what we're doing is we're assessing the incident and the response, steps that can be taken to avoid similar incidences or recurrences, and considering a review of your organization's vulnerabilities. So this would be kind of a time to, like the slide says, regroup and say, okay, how did this happen? How are we going to prevent this from happening again? All about, continual improvement. And also, it's very important that you structure any of those reviews as legal advice to protect it by privilege, because otherwise it could be subject to, a disclosure order, and then all of a sudden all your vulnerabilities are out there in the open and there's nothing you can do about it. So that's kind of on breach response. Now I've just got kind of, I think, 3 more miscellaneous topics that I just wanted to cover that I think might be helpful for you folks. So number 1, I just wanted to mention Canada's anti-spam legislation. That's something to be aware of, and I think you're probably all familiar with it in your day-to-day life, because CASL, as we fondly refer to it as, is all about providing people with the opportunity to opt in or opt out of receiving commercial electronic messages. So that's, for example, when you receive an email from the Gap or from Costco or whoever it is, there's a little button at the bottom that allows you to unsubscribe. So that is just something to be aware of. Nonprofits are subject to CASL, so you do need to be doing that if you're sending commercial electronic messages. So it's not just if you're emailing someone about, their account, but if you're sending a commercial, like for commercial purposes. And I'll just reiterate here that commercial electronic messages, in case it's helpful, those are messages that are sent by electronic means like email or text to another electronic address, with its purpose being to encourage participation in commercial activity. So that's what a CEM is. And then I think we've covered consent. And even if you do have consent, every CEM should still contain both specific information about the sender and specific unsubscribe functions. So even if they've consented, you should be providing them with that out. Now, like I said, CASL is a permission-based regime, so the regulations do provide extreme protection of recipients against organizations that are in the business of compiling and selling email lists to third parties. I don't know if any of you folks would be doing that, but that's just something to be aware of. And it does capture all CEM senders in the process, with just a few exceptions. And then I also want to speak a little bit about managing service providers. So like I said, this is a significant way to reduce privacy risks, and due diligence is really important here. It's your responsibility. Like, even if you're using a service provider, the responsibility for the data that you collect is still yours. It doesn't flow to the data provider necessarily. So when we're looking at this, we're thinking about contract considerations because typically when you have a service provider that you're going to be providing access to your information, your client's information, your program participants or information, you want to have an agreement with that service provider setting out how it is that they can use the data, for example. So when you're looking at this, you want to think who actually has your data here? Like, is it the fact that you have, Stripe is processing data on your behalf? Is it there are a number of examples under the sun, but you want to be thinking about kind of the classics, the who's, the what's, the when's, the where's. What is the data that exists? Um, do you have insurance? Who is responsible for notification? And when will notification take place? So these are all things that you want to put into a contract with a service provider that's going to be handling your clients or your program participants' information to make sure their information is protected. Because at the end of the day, you're the ones on the line and you're the ones responsible for that information. So we want to have a contract governing that. Now, for example, there's a whole slew of considerations here. I'll just go through a few of them. But one thing that you may want to include in your contract, depending on the circumstances, is um, the service provider can't disclose your client's personal information without authorization. Oftentimes, always, we want to have a data breach obligation section and response section. So, for example, if the service provider has a data breach and they're handling your data, your client's data, we want to know. So we want them to have to notify us. So we would write that into the contract. Those are just a few examples. And then the final thing that I wanted to talk about was business transactions that include personal information. So oftentimes there will be transfers of customer or in some of your cases program participant information or their loyalty information in the context of a business transaction. So there are obligations pertaining to this under PIPEDA, recognizing that you folks probably aren't subject to PIPEDA. I'm not going to get too much into it, but it is just helpful to think about on this next slide things that you might want to include in an agreement that would govern a business transaction. So if you're working with another party to complete a transaction, like the service providers, you want to make sure that they are contractually obligated to use and disclose information only for the reasons related to the transaction. So just because they have access to the information right now doesn't mean that they should be able to use it for other purposes. Or similarly, they should have to protect information by the safeguards that are appropriate to the sensitivity of the information. So we want to make sure that information is adequately protected. And there are specific provisions in PIPEDA on that, but I won't get into those because I don't think that you'll be necessarily subject to it. So that is all that I have. Those are kind of the key, I guess, privacy, security, and data breach type considerations that we typically try to highlight to our clients. And I think it's helpful for most nonprofit organizations to keep this kind of top of mind. I think I had an hour, and I think I'm right on an hour, and then we had 15 minutes or so for questions. So I'm certainly happy to take any questions that folks may have. I'm not sure if my email is posted anywhere, but certainly, Ezra, if you want to do that, folks can feel free to reach out to me about the presentation.
Thank you so much, Olivia. Would you be cool also sharing the slides as like a PDF for folks?
Yeah, absolutely. That shouldn't be an issue.
Sounds good. I do have a question from Carrie.
Okay.
What do the colors signify in the Canada graphic?
Oh, at the very start. So for our purposes, I didn't get too much into it, just recognizing that we only had an hour. But um, like I said, PIPETA is kind of the main private sector privacy law, but certain provinces have, like Alberta, for example, have enacted their own provincial laws that are deemed to be substantially similar to PIPETA. So those laws apply instead of PIPETA in those jurisdictions. That's not the case in PEI, so I didn't get into it today. But that is a good question. Thank you for raising.
I don't see any other questions in the chat. If folks have anything they want to ask, you can send it in here. I will be sharing Olivia's email. Did someone unmute themselves? I can't hear.
No, we went through a lot of info today and you may just be processing it. So certainly do feel free to reach out if you have questions after the fact.
If anyone prefers to speak too, that's fine. You can feel free to unmute yourselves. I do have a slight delay because Zoom is not being nice today, but
Thanks, folks.
so the question in the chat is, so if we're not under any jurisdiction as a nonprofit, violation on data privacy, to whom would the complaint go in the government sector?
That's an interesting question. And what I'll say about that is just that it's not, I'm generalizing when I say that most nonprofits are not subject to PIPETA, but there are some situations where you might be. And it is quite an involved legal analysis to determine that. But typically what would happen is you kind of fall in a bit of a no man's land situation. So you wouldn't actually be reporting the complaint to the government. It would just kind of go to you. There could be, in theory, some sort of common law issues, like someone could, in theory, sue the organization, I guess, potentially. That doesn't really happen often in my experience, but you kind of fall in a bit of a catch-22 situation. And I will say that Canada is in the process of revamping its privacy laws. Many jurisdictions are doing it at a provincial level. I know in Nova Scotia here, we're redoing our freedom of information legislation. It just brand new. And there's also been a lot of talk about revamping PIPETA. That was kind of in the works in the last, I guess it must have been about a year ago, and then it died on the order paper. But I think we are going to see change on that soon. We're just not quite there yet. But my advice to you is just act as though you are subject to PIPETA and conduct yourselves in that gold standard manner, and you shouldn't run into issues.
I hope that answers the question. Thank you so much, Olivia.
My pleasure. Thanks, folks.
Sounds good. If no one has any more questions, like I said, I'll be sharing Olivia's contact, the slides, and the recording afterwards, so you can look back at it if you have any more questions. I know I probably will have questions afterwards.
Check in.
Thank you so much.
Fantastic. Okay, thanks everyone.
Have a great day, folks.